Our third case of the morning is case number 20-956, the Cottages at Stony Creek Condo Association versus the Cottages at Stony Creek. 20 minutes aside. Miss Creed?
Yes, may it please the court. Good morning. I represent the plaintiffs, the Cottages at Stony Creek Condominium Association, and members of the board of directors. We'd like to reserve 5 minutes for rebuttal.
Okay, noted.
The association asked this court to reverse the summary judgment that was granted against the association on all its counts in the amended complaint and granted in favor of JDR and the other defendants based on the statute of limitations found in section 95.11(3)(c). Here, there are genuine issues of material fact as to whether the association had discovered or should have discovered, with the exercise of due diligence, the latent stucco defects before October 2013. The lawsuit was filed in October of 2017. Here we submit that the question should be for the jury as to the exercise of the association's due diligence and as to whether it had discovered or should have discovered the existence of those stucco defects that form the basis of this cause of action against JDR. Not only are there genuine issues of material fact, but the association contends that JDR is not entitled to judgment as a matter of law. Here, notice should not have been imputed to the association of the latent stucco defects that are described on page 5 of the Woods report, because any suggestion from the 2011 CSI reports and the 2011 558 construction notice related only to the potential for water intrusion and the water drainage defects that were noted by CSI, all related to other conditions, not conditions that are the very system of stucco installation that are at issue here, but instead issues like pipes. Excuse me.
Counsel, is your position that the contractor, the general, didn't submit, that the reports themselves were not enough to essentially, I guess, for a little bit longer, shift the burden on the summary judgment motion to you? Or are you asserting that your client submitted those affidavits that your client submitted in opposition were enough to create an issue of fact?
Your Honor, I believe that the answer is both. We submit that the reports themselves, the CSI reports, especially as compared to the Woods reports and the 2011 558 notice, were not enough to create an issue or to demonstrate that there was no issue of material fact as to whether the association at that time had discovered or should have discovered those latent stucco defects. In addition, to the extent that that burden of production was met, we would submit that the association did come back with enough evidence to refute that. It's not only the affidavits of the CSI employees, it's also records from the association showing that the association repaired stucco, limited cracking in the stucco just from time to time, and considered those to be the nature of routine maintenance. And drawing inferences from the comparison of the CSI reports to the Woods reports, as a jury could do, it is clear that different jurors and different reasonable people could draw differing conclusions, reasonable inferences from the comparison of those reports.
Well, on that point, what do you think the trial would look like on the question of statute of limitations? Like, what is that factual dispute that the jury would have to resolve specifically? And assuming there would be witnesses that testify, I'm assuming you wouldn't expect the jury to just look at these reports and conclude on their own whether there's notice that there's going to be more. So what would that look like, do you think?
Well, I do think the reports play an important role because on this limited universe, JDR has compared the 2018 and 2017 Woods reports to the 2011 CSI reports. And you can view that in comparison, especially the Woods reports compared to the 2011 558 notice, to determine that there's no mention of stucco defects in that notice. But also there would be testimony and evidence from the CSI engineers who did conduct the observations and make the recommendations and the testing. In addition, the knowledge of the board members and as to what they knew at the time. And so all of that, and I believe the Woods engineers as well could testify as to what they observed in 2017. Here, JDR doesn't present any evidence other than the 2011 CSI reports. There's nothing in between really 2011 and 2017, and certainly not enough to demonstrate that at some point before October of 2013 that the association had discovered or should have discovered, with the exercise of due diligence, these latent stucco defects.
So there would need to be some differentiation needed to be made by the fact finder between the CSI reports references to stucco penetrations, whether that's that's a non-stucco or a stucco related compound that you would deal with the penetrations. CSI report does mention stucco, and then there's a summary of the CSI report that talks in terms of stucco and cracks needing to be repaired, as well as windows and doors throughout the site, all penetrations of exterior walls. So the jury would need to be able to separate out, it seems like pretty broad issues from the CSI report relating to water and this envelope being compromised in all sorts of ways everywhere, and whatever doesn't relate to that came later. Is that?
Yes, and I think what's helpful in that is to look, the jury could look not only at the CSI reports, which do, as you know, mention stucco, but it's in the context of a recommendation that destructive testing was not needed on those stucco walls of the buildings because CSI in 2011 didn't observe conditions that warranted such testing. The stucco cracking was limited to a few areas, but what's that illustrated by perhaps best is the 2011 558 notice. And certainly the categories that were then identified by the association as construction defects, nowhere in those categories is there mention of repair of extensive stucco cracking. It was really more limited to sewage pipes, well pumps, guest parking, drain lines, and improper subsoil drain terminations. So the categories listed that are even potentially relevant to the stucco installation are the unsealed wall penetrations, and that is a focus on sealing the areas around the electrical panels and applying flashing, and then the unsealing of the window head flashings. Those are not.
What's the difference between that and what the Woods talks about in terms of when different materials are coming together, there are problems? I mean, it seems like those two things could be a way of talking about the same thing using different words.
Well, I think the difference is if you look at the Woods reports and the defects that are listed there are numerous stucco defects in the very system of installation. And the second Woods report really details that explanation. So whereas the CSI report noted a few limited stucco cracks in the exterior walls, the Woods report really identifies the defects that were latent defects and hidden from view that were really from the inside to the outside. So from the wood frame to the metal lath to the weather barriers to the embedding of concrete to the application of the masonry veneer, all of those are identified and explained in the Woods report. Nowhere is that found in the CSI reports or in the 2011 558 notice. So the potential.
Council, To follow up on Judge Osterhouse's question, though, I mean, the 2011 CSI report recommends repairs to the stucco cracks. Why isn't that enough to say, okay, something's wrong with the stucco, we need to look into this? We may not know exactly what the problem is or who caused the problem, but that at least triggers the start of a reasonable inquiry into what exactly the problem is.
Well, first, because the language of the CSI report notes stucco cracking in a few areas. It does recommend sealant. Again, that's an application of sealant to the exterior. But the CSI engineers, you have to consider that language together with the language at page 1668 of the record, where the professional engineers find that destructive testing was not conducted on the stucco walls, and we did not observe conditions that warranted such testing. So if the CSI engineers didn't identify any latent defects in the entire system of stucco installation, then notice should not have been imputed to the association as a matter of law. The association acted with due diligence when it undertook to hire CSI for a visual observation and for a recommendation of further testing if necessary. But here CSI didn't recommend further testing of the stucco walls. It did recommend further testing of a leaky roof, again, which is not the subject of our claims here. And when that repair was undertaken, as evidenced by the October 2011 CSI report, again, the potential for water damage and water intrusion was attributed to not the stucco, but to the roof flashings. And so again, CSI had the opportunity to recommend destructive testing on the stucco walls to determine if there were defects below the surface, and it didn't recommend that. It only suggested that the board may want to open up a few more roofs, but again, the focus was to see whether the roof flashings were adequate.
Ms. Creed, what import does this document that I'm looking at, page 3721 of the record, it looks to be a summary of the CSI recommendations from Peter Mallory dated September 16, 2012. It has recommendations, and as to exterior walls, it says inspect the walls and repair all stucco cracks to prevent water infiltration. So it seems like there's a recommendation to inspect the walls and to make stucco repairs. But is this, what is this import does this have?
Well, I think the additional information related to that was also from Peter Mallory. Sorry, at pages, let's see, 3145 to 50 of the record. And that recommended, it did state that stucco cracks appear from time to time and are repaired. That's consistent with the evidence that stucco cracking in and of itself is not necessarily a defect. It can happen in the absence of defects. That's from the second affidavit of the CSI engineer. And in addition, it is, again, shows that to the extent there was limited stucco cracking that was repaired with the application of sealant, there's nothing to suggest that all those latent defects beneath the exterior wall had been found at that point. All of the defects that that the Woods report finds, which involve not only the stucco cracking on the exterior, but it's really more of problems that exist, again, from the wood frame to the exterior, including the improper lath not being affixed correctly, the lack of weep screeds, which allows the stucco to drain, the inadequate control joint placements, which allows the stucco to move somewhat. And all of those, again, from the detail of the Woods report, reflects that it wasn't just a question as to stucco cracking in a few areas, but really latent defects in the entire system of stucco installation, and that the only evidence before the trial court was that those were not identified until the Woods report of 2017. And those are the defects that the association has relied on to file its complaint, an amended complaint.
Counsel, is there anything in the record that explains what prompted first the CSI report / inspection and what prompted the Woods report and inspection?
No, there is not. So JDR just introduced and relied on for summary judgment the 2011 Woods reports, 2011 558 notice, the homeowner emails, which were really 2011 to 2012, and then the 2017 and 18 Woods reports. So we don't know what prompted the first CSI report or the Woods report, but we do know that CSI, upon conducting its initial visual observations and evaluations, again, did not recommend testing of the stucco walls and didn't find any conditions that warranted that testing. And again, if you compare the 558 notice from 2011 to the Woods reports, you'll see that the association itself did not ever list even the stucco cracking, the limited stucco cracks that were easily repaired and part of routine maintenance. Those weren't listed as a construction defect in the 2011 558 notice. Also, turning to the Caudill case, again, this question is one that should be for the jury, but also notice should not be imputed to the association as a matter of law. Here, the issues of potential for water defects and potential water intrusion were attributed by CSI, again, not to any systematic latent defects in the stucco installation, but to issues like the sealed head flashings over windows or the improper or inadequate roof flashings. And so to the extent that those potential conditions did exist, as in Caudill, those conditions, the potential for water intrusion was attributed to causes other than the ones that JDR now sues on. And under Caudill, and especially as explained by the 4th District and Performing Arts Center Authority and Snyder, that's not enough to impute notice as a matter of law. When it's not a roof leak case, here it's not, we're not suing on the roof leaks. And so when it's not obvious that the leaks are the fault of someone, then the question is whether the association had discovered or knew enough or should have discovered with the exercise of due diligence, whether that those latent stucco defects existed more than 4 years before the lawsuit was filed.
Ms. Creed, you are into your rebuttal time. I just wanted to make you aware.
Thank you. I'll wait and reserve the rest of my time for rebuttal. Thank you.
Thank you. Ms. Roberts.
Thank you, Your Honors. May it please the court, Abigail Roberts on behalf of JDR Construction, who is the general contractor. Your Honors, I was a trial attorney who argued the summary judgment motion before Judge Falgren that we're now here on appeal. So, Your Honors, I think that the association's coming here on appeal and saying, we didn't know. But the undisputed record evidence clearly shows that they knew. The CSI reports, so that's 2 separate reports in 2011, they identified widespread and obvious defects in the roof, the stucco, the windows, the doors, the balconies, the ground systems, the drainage, the pool area, and other components at this property. So before I sort of walk through the history, I think it's really important to note the appellant's taken the position multiple times in their papers and here, this isn't a roof leak case. But that ignores the fact this was a roof leak case. They filed suit for roof leaks and for windows and for doors and for all sorts of building components. And the only reason we're not here talking about those today is because the appellant has conceded that the 2011 report was sufficient to trigger the statute of limitations. So they did not appeal the court's order granting summary judgment and establishing that the statute of limitations bars the claims for roofs and for windows and doors and for certain ground components. That's already the law of the case. So what the association did with those CSI reports is they copied and pasted them into a Chapter 558 pre-suit notice of claim for construction defects. And they identify roof issues, stucco issues, numerous other areas at the project as construction defects. And so to be clear, this is a stucco building. So when we're talking about exterior wall penetrations, that's stucco. It's all contained in the same section of the CSI reports, and they're all contained in the same section of the Woods reports that we received.
Now, Ms. Roberts, is there some differentiation that needs to be made by a fact finder, perhaps between the surface crack related issues that could lead to water damages that were noticed and could be identified in 2011, 2012, and latent defects of things that are happening beneath the surface that weren't so observable in 2011, 2012, and that those could be the things that this case is concerned
Well,
with?
so the answer to that is no, and here's why. Number one, when we're talking about a motion for summary judgment, we're talking about the record evidence. All of the record evidence reflects that they knew that there were stucco deficiencies at the property. I'd like to refer you to the association's corporate representative deposition testimony. This is on page 1706 of the record, in which she testified. And here's the question. In 2017, before this lawsuit was brought, was there ever a discussion that you recall of, we have roof problems and stucco problems, and we need an engineer out here to look at that? Do you recall that occurring? And she says, well, we've had some of this, and even like this one with Weinsinger, and I'll go through that in a moment. Question, right, dating all the way back to 2012. Answer, just some general discussions, yes. And so what we're talking about here is a standard that involves knew or should have known with the exercise of reasonable due diligence. And courts throughout the state of Florida, up to the Florida Supreme Court level in Almond, and of course Kelly, which has stated that the plaintiff cannot rely on the lack of knowledge of a specific cause of a defect to protect it from the running of the statute of limitations. And so
Counsel, you as the movement need to show that there's no dispute as to whether they reasonably should have known.
Correct. And there is absolutely no evidence in the record that shows that they either did it that, well, first of all, the record evidence all shows that they knew. I mean, all the record evidence
knew about the CSI report.
They knew there were stucco problems, roof problems, and other building issues. And so
right, not necessarily defects.
Well, that's not what the law requires. And so the Florida Supreme Court in Kelly and its progeny and all the way through has articulated the proposition that the plaintiff cannot rely on the lack of the knowledge of a specific cause of a defect to protect it from the running of the statute of limitations.
Well, cause of defect and defect are two different things.
I'm sorry?
Cause of defect versus defect are two different things.
Correct. So here they knew it was a defect. And I'll tell you why. Number one, they identify it in the May 13th and the 2011 558 notice as a construction defect. And secondly, I think it's important to differentiate Caudill from what is really applicable here, which is Hochberg. And so what we're talking about in Caudill was a true latent defect. It was an underground piping system that they knew they had leaks when the initial construction was going on, but the contractors told them this is related to either incidents that occur during ongoing construction projects or to something that's not really right. So they said it was something related to ongoing construction. Now, what we do learn later on is that the actual corrosive elements that occurred, which was what was causing the leaks, would not have been possible to have been occurring during ongoing construction because they were caused by this galvanic clay. And so in that case, it's really different than what we have here because they had, again, a hidden defect that's underneath the building. And they had an engineering contractor telling them, this is related to something else. What we have here is the opposite. These are obvious defects. And I think it's important, and I say this very respectfully, that I think this represents a misapprehension of a building envelope system because the stucco crack is the defect. That's the manifestation of the defect. Just like if you have water coming in through your ceiling as a manifestation of a roof leak. So the defect
In which specific parts of the CSI report? Because it seemed to be a little bit of a disconnect between the chart where it says we're matching up the Woods report with the CSI report and suggesting that here are all the things where the CSI report, or here are all the places where the CSI report mentioned the things that the Woods report said. But I was having a hard time actually finding those specifics, especially with respect to the stucco defect. So are you able to, and I don't, if you can't, because this is OA and I don't want to put you on the spot too much, but if you have it handy, are you able to point us specifically to where in the CSI report it tells you, like, beyond a doubt or without dispute, that here's the defect identified in the Woods report?
Sure. So in the May 13th of 2011 report on page 1659, it talks about that how the CSI, they contracted to perform a visual condition evaluation of the building envelope system, including windows and doors, flashing issues, and roofs. And so under the exterior wall section, it states, there are many penetrations through the exterior walls in the building that are not adequately sealed. This condition can lead to structural damage and water intrusion if it is not addressed. These areas can be sealed with the application of the appropriate sealant. The areas above the electrical panels require drainage flashing. The electrical panels are particularly vulnerable due to the size of the penetrations behind them. It then goes on to say in that same section, stucco cracking was observed in the few areas during our investigation. Such cracks should be sealed to prevent water infiltration into the building. So when you turn to the 558 notice, under unsealed wall penetrations, and this is page 2103 of the record, they state description of claim. There are many exterior wall penetrations that are not adequately sealed at the time of construction, including electrical panels that are not adequately sealed and do not have drainage flashing. This is a construction defect within the definition of chapter 558.003. And then it talks about, and this is where I think we're missing the mark, then it kind of describes how this condition can lead to water intrusion. So the condition itself, the exterior wall penetrations, that's the defect, and they knew about it. And I think it's really important to note that CSI, when we're talking about destructive testing, all they're saying is, I don't need to do destructive testing. I can see it on the outside of the building that there is a stucco crack. But they did say, based on what we're seeing here with all these systems, and you have to keep in mind, just as the Woods report talks about the interplay between the stucco and the flashing and the weather barrier and the roof, these are all interconnected systems. And so what they said was, we have serious concerns about whether the contractor understood how to apply the weather barrier system as part of this full building envelope. So what do they tell?
But isn't that kind of a jump, though, to say, okay, there were some minor problems, $8,000–9,000 worth of problems. It's not very much for a HOA to fix. To jump to the numerous problems identified in 2017 with the stucco system?
Well, the answer to that is threefold. One, under traveler's indemnity, that conflates the knowledge of an issue with the severity of the issue. Knowledge as to whether or not we know something's going on, and the association clearly knew that they had widespread deficiencies in their building envelope system in 2011. And I'll refer you to, and I think before, let me finish asking the question, then I'd like to jump on and just tell you how they knew in particular that this was going on. But second, by definition, if the association is serving a Chapter 558 notice for construction defects, they are saying it's widespread and systemic and common to all unit owners. Because if they weren't, they wouldn't be able to serve a notice of 558. It has to be matters of common interest. So
well, the fact that the 2011 558 didn't include nearly everything with regard to the stucco that came out in 2017, isn't that potentially evidence of the HOA's knowledge that should be sorted out by a jury?
Well, Your Honor, at the time to have done that would have been at the summary judgment stage. The undisputed evidence shows that they knew that they had stucco problems. And in fact, I think it would be important to refer you to the considerable discussion that went on within the board for years following this incident, in which with the discovery of these defects, in which the past and future president is literally begging the board to file suit based upon these defects. And what they even went so far as to interview 4 separate law firms who advised them that they had a good cause of action. And in the August 14th of 2012 presentation given to the board by the past and future president of the board, he identifies exterior building deterioration as a construction defect. And he talks about these 4 law firms, and he says there were 2 common threads in all the opinions we received. We have a good cause for legal action against the developer, and we have a stronger case as an association than as individuals.
Well,
And
let,
then
let me give you an analogy. I don't know much about stucco other than what I've tried to read through the extensive record. But say somebody installs some windows, right? And come to find out the windows, immediately after installation weren't properly caulked. So, you make a claim and say $500 to come out and caulk all the windows in the house, and that gets done. Come to find out 5 years later, the windows themselves were defective. So, I mean, there's been a problem with water intrusion. There was a defect in the installation. But that overall structural defect with the whole project shouldn't be imputed on the homeowner just because there was a little minor defect at the start, right?
Well, I suppose that there could be a scenario in which that is true, but under the facts of this case, where we know that they were advised about stucco deficiencies back in 2011, we knew that they then identified the exterior building penetrations as construction defects in 2011. And we're talking about a widespread system as opposed to, say, Caudill or Performing Arts Center or Snyder, which talk about, as you mentioned, one discrete issue. This is a different scenario. We're talking about widespread and obvious defects. And so I think the most appropriate case to analyze this is Hochberg, because in Hochberg, what we had a homeowner who, as soon as they moved into a home, they noticed a musty smell, and they had wall cracking, things along those natures. They knew they had water intrusion, but they really didn't know what was going on. They then looked around the house. They found other things, tile cracking, pool pavers that were settled, things along that line. And so in that case, they had widespread and a wide variety of different construction defects that they were aware of, or at least that they could visually observe. And so what they attempted to argue to the court and at the appellate level too, was that we didn't know exactly what was going on, and we didn't know who to sue for it. The court said, no, you don't get to hide behind the fact that you don't have a specific knowledge of the cause of this defect. You were certainly on notice that something was going on at your property. And at the very latest, we know that you had notice at the time that you served a notice of demand for arbitration to the subcontractors and the contractors who installed some of these building components. And then later on, more than 4 years after that, they ended up filing suit. And so when we're talking about, so I think that's really applicable here. And I think it's also really important to note 2 things. Number one, there is no record evidence. This solely ipsa dixit of counsel that the association believed this was a maintenance issue. There is no record evidence from anybody that states the association knew. At best, they have an untimely affidavit that was referred to in the initial brief that was filed 5 months after the summary judgment hearing, in which one of the engineers said, I believed it was routine maintenance, but he didn't say that he told them that. And I think
wasn't it incumbent upon your client though to submit some evidence to put these reports in context? Because it seems like you're submitting some reports and asking the trial judge to compare them and reach some sort of legal conclusion as to them. Why not submit some deposition testimony explaining these meeting minutes, or explaining why these reports were done in the first place? To help us, basically to carry your burden of showing that there's no dispute.
Well, to answer your, I'm sorry, I didn't mean to.
No, go ahead.
To answer your question, we did. We submitted the sworn deposition testimony of Colleen Baker, the corporate representative.
Well, right. And she really didn't answer many questions substantively on that point.
association's issue if their corporate representative wasn't properly prepared, but there is.
Well, but your burden is to show affirmatively that there's no dispute of fact, and you didn't
Right.
have to just take the corporate rep depo. You could have taken the depo of any of the people that wrote those emails or spoke at the meeting, because I have a separate question as why you think or how you would get any of those emails or the minutes into evidence at a trial in the first place.
Well, Your Honors, first, there was no objection to that at the either in the deposition or at the summary judgment hearing or at any point until now. So that was actually, and we know that in order for that to have been preserved before the trial court, they would have had to make that a specific objection while the summary judgment was being presented. So the undisputed evidence from Ms. Baker is that in 2012, we knew that we had roof and stucco issues. I also don't put much in the association's argument that they had no opportunity. These were true latent defects that they didn't know about. And here's why. The CSI folks did in May of 2011, they said, we've got some serious concerns with the building envelope and whether or not the contractor knew what to do, with the application of this weather barrier system. So next time you have an opportunity, you need to open these up. You need to check it out. So sure enough, they do. In October of 2011, they get that opportunity. This is page 1673 of the record. They cut back the stucco. And what does it state? In the CSI report, quote, the only defect noted during the demolition was that the paper-backed lath was installed paper over lath instead of paper over paper and lath over lath. Defects were noted beneath the shingles and the underlayment was wet. So why is that important? Because in 2017, after we received the untimely lawsuit, we do finally have destructive testing by Woods. And what do they say in the stucco section? As a defect in 100% of the locations, paper-backed metal lath was improperly lapped paper on metal at each location. And then in their next report in July of 2018, they say 100% of the locations it noted improperly lapped paper-backed metal lath. And so had they, first of all, not only did the undisputed evidence, and again, the association didn't present any evidence to dispute the fact that people were saying we had knowledge, this was in the record, we knew that there were stucco issues, we knew that we had a right to sue. Not only that, we have actual knowledge, but they surely had a duty, had they investigated as their association's board members were urging them to, they would have even found out the actual cause of what was going on. The law clearly provides that you need to have a general knowledge. We don't charge homeowners with having to know every single construction defects, but they do have a duty to know what's going on around their property and to act diligently. And so when we have the past and future president of the board in May of 2012 saying appropriate research, which includes engineering reports and ultimately a legal assessment of that research, is necessary before these claims and possibly others that may be uncovered in the process can be evaluated. Then and only then can a rational decision be made whether to proceed with the legal action or to dismiss the opportunity and accept the burden of paying for everything ourselves. Time is running out to hold the developers accountable. There can be no question that the association had the knowledge that has been articulated in Kelly and Almond and Hochberg and cases throughout the state with respect to the fact that they knew there was something going on. And at the very minimum, they had a duty to investigate. And the association has presented no evidence that would suggest that this notice did not exist. So based on this, I would ask this court very respectfully to affirm the order on the motion for summary judgment.
Thank you, Ms. Roberts. Ms. Creed.
Yes, a few points in rebuttal. First, to the extent that the notice or that what the association had discovered or reasonably should have discovered with the exercise of due diligence, you can look to the construction defects listed in the 2011 558 notice. And there is nowhere in that 2011 558 notice any mention of cracking in the stucco, sealing of the stucco. There's certainly nothing to suggest the latent systemic defects in the entire system of stucco installation that are identified on page 429, which is page 5 of the Woods report. So to argue that at that point that this 2011-558 notice itself demonstrates what the association knew, much less it doesn't demonstrate what the association knew in terms of construction defects, certainly doesn't determine or demonstrate that at that point in time, the association had discovered or should have discovered with the exercise of due diligence, these construction defects that are identified by Woods in great detail in 2017 and 2018.
Counsel,
Sorry.
why wasn't it enough to submit that that they submitted the CSI report and the former president's statements that were just read? Why was that not enough in front of the trial judge to conclude that your client was on notice, barring anything submitted by your client in opposition? And it doesn't seem like there was, just those two affidavits. So why was that not enough to shift the burden to you? And how is it that your client met that burden to get to trial?
We met that burden by some of the same evidence that JDR relies on, which is when you look at the defects that are the basis of this cause of action, which are the defects listed on page 5 of the Woods report, and then you compare that to try to show that the association had discovered or should have discovered those defects in 2011, you can draw a reasonable inference from the comparison of those documents to show that at that point in time that the association had not discovered and reasonably should not have discovered with the exercise of due diligence those defects, those specific latent defects that are listed. This case is not like Hochberg. In Hochberg, the homeowners essentially admitted that they had knowledge of construction deficiencies. They had originally filed a demand for arbitration against the general contractor and then later sought to file a lawsuit against the specific subcontractors. That is not our case. I see that I am out of time, but I would ask this court to reverse the summary judgment based on Caudle, and where there are genuine issues of material fact as to whether the association had discovered or reasonably should have discovered these stucco defects that, based on this record, were not identified until 2017. Thank you.
Thank you, Ms. Creed. That is our final case of this morning, so the court will be in recess.